Hi guys, I'm here live with my good friend Kim Hong, who's a family law attorney in California. She's been practicing for 16 years with additional experience even before she was a lawyer. And she and I were having coffee a few weeks ago, and we're talking about how a lot of my immigration clients could benefit from her family law experience. And she was saying how some of her clients going through family law issues could benefit from some immigration law information. So we thought we would sit down and have a virtual coffee to talk about just education, information stuff. No legal advice today, but definitely lots of hopefully helpful information. How are you doing, Kim?
Pretty good. How are you, Hillary?
I'm good. It looks like it's nice and sunny in California. I wish that I had some sunshine warming my office right now as well.
Yeah, we're pretty fortunate here.
So, some questions about marriage today in the United States. Can you tell me what do you need to do? I know every state is different, but how do you get married in the United States generally?
Generally, from what I understand it, especially in particular in California, you just basically walk in, get a license, and from there fill out some forms, and they issue a license, and from there you just get married.
What kind of documents do you usually need to get that license?
Well, in California, as far as I understand it, basically they just ask some very preliminary questions: your name, your address, whether you've lived together. And perhaps potentially, if you've ever been married previously, but other than that, they don't really ask about anything in particular, probably like immigration status. They don't really ask that.
Okay, so someone who is here without documentation or they've overstayed a visa or something like that, at least in California, and I know this is true in Arizona as well, no one's going to be asking any questions and they're really not concerned with that. Is that right?
Yeah, that's correct. They're not concerned about your immigration status when you go in to get married.
Okay, awesome. So lots of clients get married. Unfortunately, some clients get divorced. Can you tell me about what the process is for getting divorced?
And in California, the only requirement is that you have been a resident of California for at least 6 months prior to the date that you file for the divorce. And essentially, that's really all they ask. They don't really ask again about any immigration status. I know that comes up when I meet with my clients and they're intending to go through with a divorce. Their concern is always, well, can I file for divorce, or what are the consequences if I don't have status here and I go in and I file for divorce?
Mhm.
So those are the questions that I get asked, and perhaps you can elaborate because I'm not exactly sure. You know, any other than I tell them that's fine, but as far as the immigration consequences, maybe you can kind of elaborate on that.
Sure. I think that really depends on if a person has are you saying perhaps if they have a pending petition for a green card based on their marriage?
Yeah, so they have a pending green card, or even potentially if they're not here, they're here without papers.
Okay, so those are two kind of different scenarios. The first, if
Hmm.
you get married to a US citizen and you have no immigration status here, or your immigration status, you were basically relying on the track that you were on based on your marriage. If it's a pretty young marriage, if you've been married for less than 2 years, and that's during the time that you have applied for your green card, basically, if it's within a year and 9 months of getting your green card, you have what's called a conditional green card, conditional residence. And typically you would need to file with your partner, your husband or your wife, who's the US citizen, to have those conditions removed. So then you just have a regular green card. Now, the divorce is going to complicate that if it's before that year and 9 months or the 2 years that the conditional residence is up. It's not necessarily going to ruin your possibility of being able to have those conditions removed. It just means that perhaps your ex is, if it's an amicable split and you're still friends, or at least you're still working together, to where the ex would still petition and show that the marriage itself was entered into for legitimate reasons, but it just didn't work out. Alternatively, you can still self-petition and show with your own evidence that I married this person in good faith. It just didn't work out. And that happens a lot of times. So the best thing would be to talk to an experienced immigration lawyer who can help someone kind of navigate that process. That's what I would suggest doing.
That's great advice.
So then the $1 million question is when we have custody issues come up. Lots of people who don't have status, I know, in the United States, or perhaps they do have status, but they're still concerned that somehow they're not going to be able to obtain custody of their kids. And they're just really curious and concerned about the basics of that process. And I know it's unique in California and different in Arizona, but what would you say is the process in California for child custody?
So for child custody in California, they specifically, the factor that they looked at or the standard is the best interest of the children. So immigration status doesn't necessarily come into play when you make a determination on what's in the children's best interest. Because what they would really look at is who can provide the proper care for the children, who can make sure the children are fed, their homework's done, they get to school on time, and things like that. But it does come up occasionally in a situation where there is what's called a risk of abduction. So there's strong ties and to perhaps like Mexico. A parent has really strong ties to Mexico, and not only that, but has engaged in certain conduct that shows that there could be a potential risk of abduction, such as unilaterally attempting to apply for a passport, shutting down their bank account. So just certain behaviors to indicate that there is a risk that they're going to take off and go to Mexico with the children. But other than that, for the most part, it's just again the best interest of the kids. Immigration status doesn't come into play. They just look at who can provide the best care for the kids, for their health, their safety, and their well-being.
Okay, great. And is there typically, is there like a default setting, a default that a judge would usually, 50-50 or predominantly goes to mom or predominantly goes to dad? Does that still exist in California?
In California, um, the goal I think is frequent and continued contact. Not I think, but I know the public policy of California is frequent and continued contact for both parents. So the goal is 50-50 for both parents, assuming that there are no risks of harm to the children. So if there's no domestic violence and there's no child neglect, then the goal is typically 50-50 if it's plausible. There are certain situations where, parents, they move to different cities, different counties, and that makes it a little bit difficult.
Sure.
So at that point, they kind of adjust it. But the goal is to try to maintain as close as joint custody as possible.
Okay, great. That's wonderful information. Thank you.
Mhm.
So, if any of my people or anyone who's watching this needs a family lawyer in Orange County, California, check out Kim Hoang, the law offices of Kim Lynn Hoang, and she will be able to help you out. And if you need an immigration lawyer in Arizona, get law offices of Hillary Gaston Walsh. And for now, Kim, it's been great. I look forward to more coffees with you.
Thank you. It's been wonderful.
See you later.
See you later.